Okay, let's get started.
Commissioner Odero? Commissioner Kesher? Here. Commissioner Wasserman?
Here.
Commissioner Nguyen?
Here.
Chair Remke?
Here. Okay, good morning, everyone. Before we get started, or I guess the first item is there any public comment for an item that is not on the agenda today? Okay. Okay, sure, please.
For the next minute, I will be a member of the public. I really just wanted to congratulate Jody on doing a great job in front of the Senate Elections Committee last week. She talked about the importance of transparency and simplicity in the work that we do here, and I just thought she did a really good job and represented us well. So thank you.
Thank you. Okay, seeing no other public comment.
Madam Chair,
Yes.
this is Commissioner Wasserman. I just wanted to note for the record that the agenda has been posted here at the Law Library in Los Angeles, and there are no members of the public present. Thank you.
Okay, thank you for that. All right, item 2 is the approval of the November 2015 committee meeting minutes. Are there any comments or corrections from the commissioners? Is there a motion?
I move to approve the November minutes.
Second.
Commissioner Odero?
Yes.
Commissioner Kesher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Nguyen?
Yes.
Chair Remke?
Yes.
This motion passes.
Great. Okay, items 3 through 24, the proposed consent calendar on enforcement matters. Would the commissioners like to take any item off consent, either because of a conflict or a vote? I'll just remind everyone that we don't need to take it off consent if just to ask questions or if we have comments. Anyone like to take anything off consent? Okay. Do the commissioners have any questions or comments about the items on consent?
I do.
Okay. Commissioner Nguyen?
So I had a question about item 4 and one about item 7. Should I just ask them in that order?
Sure, let's do one at a time. Let's take item 4 first.
Okay. Hi, Galena. So it looked to me.
Ms. West, would you like to introduce yourself?
Go ahead.
There we go. Technological difficulties. Galena West, Chief of Enforcement, ready to respond.
Good, thanks. It looked to me like there were 6 counts on this item, and there were about 4 things that you mentioned in mitigation, but there was still the maximum penalty imposed. And I just wondered if you could walk us through that.
Certainly. For laundered campaign contributions, maximum fine is our typical penalty. But when we deal with contribution limits that are quite low, like in this case, the contributions were a total of $3,000 because the contribution limit was $250. Then what we do, instead of weakening our max fine for laundered campaign contributions, in order to try to find some equity in these cases, we consolidate counts. So in this case, there were 12 alleged that we had some evidence of, and so in order to only have the fine to be 10 times the amount of the contribution, $3,000 to a $30,000 fine, we consolidated those into 6 counts.
Okay, that makes sense to me. Thank you. I figured there was something there. I just couldn't find it. I don't know if others have questions on this item.
I just have a comment. I do understand that this case comes out of the proactive work of the special investigators led by Sandra Buckner, and I just want to kind of give them credit for their hard work. And if you could tell us a little bit about what that involves. I know it's very labor intensive when they're doing these proactive laundered cases.
It is. Our supervising special investigator, Sandra Buckner, leads a team, and what she does is identify jurisdictions in order to look at campaign contribution limits in those jurisdictions. And it's very labor intensive because then they have to get the campaign statements, put those into Excel spreadsheets, the information, look for patterns. We have a designated pattern that we look for that Sandra and the attorneys have come up with. And once we identify a pattern, then we have to get bank records and do interviews in order for these cases to come to light. So it's a lot of work, and they go through meticulously and find these patterns in order for us to be able to prosecute these cases.
So I think we're really lucky to have that team. And I think it's a good signal out there that we don't just wait for the complaints. We are doing this proactive work where it matters. So I thank you for your work.
I have a couple questions.
Sure.
So you answered one of them, which was, I counted 12. So I understand that you consolidated, but doesn't consolidation then in essence dilute the value of the mitigation? I mean, don't we then kind of eliminate the record of there were some mitigating factors that therefore we're not going to apply the full amount? And so historically, let's say I wasn't here and I come in, 2 years from now, I'll never know that there was this mitigating factor that in essence, truthfully resulted in a reduced penalty, and there's no record of that.
Actually, this does give you more of a complete record doing it this way, because what has happened sometimes in the past, the commission has instructed they would rather, this is years ago, they would rather not know about the things we're not charging and then do just based on the story that's in the facts that we present to you. But then with CPR requests, we get public records requests, then later on, you would find out that there were other charges that were possibly part of the story that you didn't see. So what we do instead now is we tell a more complete story to where you learn about all of the allegations, and then the mitigation is used to reduce the number of counts rather than the fine amount. So it's still used and it's still presented to you to where you get all of the facts, but then it's applied in a different way.
So why is that? Why is it that we don't say there are 12 counts, but the mitigation value is we're going to reduce the penalty by 50%? Why is that not as good as what you are proposing?
I think that the reason that we do it this way is because since laundered campaign contributions are one of the most serious violations, you'll also have another case to where there's only 3 counts that can be proven. And so you don't want to have these comparable cases out there that have a $3,000 laundered campaign contribution amount that has been charged by the commission, and then use that and then have to say so much aggravation in order to go to max fine. The commission, having said in the past that max fine is what they require for these, then it's up to us to present it and say, okay, max fine is what you require, but here's the mitigation that says, but we're not going to charge all 12 counts, because then it would be a $60,000 fine for a $3,000 activity. So what we try to do is use it in a way that tells you the entire story, but then also lets you have the information that shows you why it's not 12 counts.
So you just want more, I'm just trying to understand. So are you looking for more of the kind of that analysis in the STIP? There was 12 counts, but we're only charging 6 because of the low fine. I mean, the thing we're hearing today?
Yeah, no, I mean, I not so much in the STIP, because this is the exhibit 1 is part of the record anyway. So I'm fine with the explanation. My question is, it seems to be saying we're only able to prove 6 counts, and I don't think that that's correct. I mean, correct me if I'm wrong, but from what I'm reading, I think we were able to prove 12, right? But there were mitigating factors as to all 12.
I think it's more, we are charging 6 for purposes of these settlement talks. And that's how we try to phrase it. And then whether or not we could have proven 12 would have been up to an ALJ or however we did
Fair enough. Fair enough. And then I have a second question, which is, when we're looking at the mitigating factor of intent, are there interviews of these people who, like, what did he say to you when he said, write a check for $250? Do we have that information?
We, as part of these proactive laundering investigations, we go out once we have records, financial records, and interview everyone that has been associated with it. You wrote this check, or do you contribute to other campaigns? Were you reimbursed? Here's what your bank records say. And so we do get the full story. And then also we always try to give the respondents an opportunity to respond and give their statements. We never want the respondents to have a case against them where they never had an opportunity to respond. So in this case, we interviewed the respondent and we were given evidence to support his allegations are written in the assertions are written in the exhibit as to being given bad advice by other community members on this is what you're supposed to do in order to get more parking spots. This is the way that the system works in this jurisdiction. So that was the statements that he gave us.
Okay, thank you.
Are there any more questions on item 4, or we'll move to item 7?
Well, item 7 is the exact opposite question, which is it's a default, which, means that, they weren't as cooperative, there weren't items in mitigation, and there was a lesser fine than you could have gotten. So I'd just love to hear the thinking on that.
Certainly. This is a default that's a little bit different than other defaults in that Mr. Santiago and his treasurer / ex-wife, I believe, were in office at the time, cooperated in that they filed all of the missing statements, asked for time to come up with a fine amount to pay the penalty, and were unable to. And so as it progressed, then since they had all the filings and he was removed, he resigned or was removed from office, he's no longer in office. So he meets our criteria for not max fine in a default since all of the statements were filed and he's no longer in office.
Thank you very much.
Any other questions on item 7? Okay. Do the commissioners have any other questions regarding the consent calendar?
I do on item 8.
Okay, please go ahead.
So as I read this, I found this particularly horrifying. This is a person who is a former attorney who's running for a judicial position. We hold our judges to a much higher standard on just about everything under the sun. And I am troubled by the game that I perceive this to be a game that was played of where are it's like a shell game here. Where is the money? Where is it coming from? And it seems that it's just the mitigating factor of she didn't know the law to me is a little bit stretching it for a former lawyer. I looked her up. She's a former prosecutor, no less, and somebody who was running for a judicial officer. And then I found also particularly interesting, and I make this as just a note of interest, not anything else, because this is between her and her friend, but she was paid 10% interest on the loan to the committee, and she did not pay her friend 10% interest. That's just kind of a side note. But but I find all of this, when you put all of this together, I find it very interesting. And again, I'm going to say the word that stuck out, that came to mind, I think, as I was reading all of these, and maybe it's because I'm new, but I do find this horrifying. And it seems to me that I think she should be fined the full amount.
I understand your concerns, but I think the issue is before us, not her candor or ability to hold judicial office, which would go before the Commission on Judicial Performance, because I think you raised some of those issues. I'm just saying, from my point of view, we got to look at this not just because she's a judge, treat it differently. We have to treat it for the purposes of campaign violations. And I would be concerned if we start elevating fines based on the position someone holds. Again, I think it's a valid concern, and perhaps the State Bar and or the Commission on Judicial Performance would be concerned about if there was, in fact, any intentional misrepresentations, which I don't think we have evidence of.
Yeah, no, and so just to clarify for the record, and the fact that I might one day practice before this, I am certainly not calling into question her ethics as a judge. Absolutely not. I am just saying judges are held to higher standards. And if anything, she wasn't a judge yet. And as she was making these decisions, she was an attorney who had access to the law, who knew how to read the law, and in fact, a former prosecutor. That's the point.
And I would just say the reason that, and this is pretty close to max fine. So the second count is about major donor, but we're really talking about count one, which is how they reported the loan on the campaign statements. So they're being charged $4,500 as the amount out of 5,000. And the reason for that is the comparable case where we've done 5,000. There have been other cases where the charge has been for 3,500, but in the case that was cited in the exhibit for 5,000, there was a circumvention of limits. And so that's what warranted the max fine. And so since other cases that were similar were more 3,500, 4,000, we did take into consideration that this seemed to be something that she was doing that she should have been aware, and we upped it to 4,500. And without the circumvention of the local limits, looking at the comparable cases, we tried to take that as guidance, and that's why it's 4,500 and not 5,000.
Okay, thank you.
Are there any other comments on item 8? Would you like to pull item 8 from the consent? Is that, you want to vote separately on that,
No.
Commissioner? Okay,
No, I just need a clarification. Thank
Okay.
you.
all right. Any other questions or comments from the commissioners on the consent calendar? All right, are there any public comments for items on the consent calendar? Seeing or hearing none, is there a motion?
I move to approve the consent calendar items 3 through 24.
Second. Commissioner Darrow,
Yes.
Commissioner Kesher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes.
This motion passes.
Thank you.
Thank you. Glenn, are you gonna, yeah. Okay, so we'll move to item 25, the Regulation 18996, Scope of Audits and Investigations. Good morning. Can you please introduce yourself?
Good morning, Chair Remke and fellow commissioners. My name is Matthew Christie, and I'm here on behalf of the Legal Division to present proposed amendments to FPPC Regulation 18996. These amendments to Regulation 18996 are designed to help ensure the efficient use of state resources. The Political Reform Act requires routine mandatory audits and investigations of the reports and statements of campaigns and lobbyists, lobbying firms, and lobbyist employers. The Act sets forth methods of selection, criteria to qualify for selection, and schedules for those audits and investigations. The Act also authorizes the FTB and the FPPC to conduct discretionary audits and investigations of any reports or statements required by the Act. Former subdivision C of section 90,002 set forth limits on the reports and statements that could be considered in a mandatory audit or investigation conducted pursuant to section 90,001. Prior to the adoption of Regulation 18996 and 1999, a literal interpretation of former subdivision C of section 90,002 arguably required a mandatory audit and investigation of all statements and reports that a candidate filed during the election cycle, including those that the candidate filed for another election wholly unrelated to the election subject to the audit and investigation. Regulation 18996 was adopted to clarify that a mandatory audit and investigation under section 90,001 was prohibited from including statements and reports filed in conjunction with an election for any other office. The proposed amendments that will be up for consideration today would restate the FPPC's limitations on mandatory audits and investigations of campaign statements and reports under section 90,001, previously contained in subdivision C of section 90,002. They would strike restatement of former subdivision C of section 90,002 and cross references to that provision. And they would clarify the FPPC's authority to exclude from the selection of jurisdictions required by Regulation 18991 any jurisdiction that is subject to audit by a local agency or the FPPC.
Do the commissioners have any questions or comments regarding this proposed regulation? Everyone saw in the packet from the FTP, the letter supporting this, correct? Okay. Any public comment on item 25?
Hi, Chair Remke, members of the Commission. My name is Nicholas Heidorn with California Common Cause. I want to comment specifically on the aspect of giving the Commission the discretion to exclude cities that have established ethics commissions from the random audit. As a measure of avoiding redundancy, that makes perfect sense, but I just want to point out Common Cause has looked at many local ethics commissions and they come in varying quality. Some don't really have much of a record of enforcement, and we know in some cases these commissions can cease functioning. For example, the City of Oakland now has a good ethics commission, but a few years ago during the recession, they got rid of all staff and ceased functioning. So the only thing we would counsel is that when you go to implementing this, make sure it's not a blanket waiver of random audits for any city that's established an ethics commission, but look at the quality and caliber of each ethics commission when you make that determination, whether to exclude them from random audits.
But
Thank
you understand that the regulation still provides the enforcement division with complete discretion as to what local jurisdictions to audit.
Yes, I'm only suggesting when you exercise that discretion, it should be case-by-case basis as opposed to adopting a blanket approach to
Right.
cities with ethics commissions.
Hence the meaning of discretion. Thank you.
Yes.
Any other public comment? Is there a motion?
I move approval of the proposed regulation for 18996.
I'll second. Commissioner Darrow?
Yes.
Commissioner Kasher? Yes. Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Remke?
Yes,
This motion passes.
thank you. Okay, item 26, which is adoption of regulation 18944.1 amendments on gifts, agency-provided tickets, or passes. Is that?
Good morning, Chair Remke and Commissioners. Val Joyce, Commission Counsel Legal Division. Today, we're proposing to amend Regulation 18441, which allows employees to accept from their agencies tickets or passes to entertainment events without being held to the statutory restrictions on receiving gifts. Ordinarily, tickets and passes an agency provides to agency officials for entertainment, amusement, or recreational events are regarded as gifts. Regulation 1844.1 creates an exception from the definition of gift for tickets or passes that an agency provides to certain officials, so long as the agency complies with specified requirements. And in particular, the use of the ticket must further a governmental or public purpose. The agency must adopt a distribution policy that contains provisions set forth in the regulation. The agency must complete a form for each distribution that must be maintained as a public record and subject to inspection and copying. And the agency has put together a Form 802 for that purpose. And the form for each distribution must be forwarded to the FPPC for posting on our website. First of all, the proposed regulation would impose a deadline as to when an agency must provide the required information. Currently, there's no set deadline, and our original proposal, which is before you, was to set a 30-day deadline. Subsequently, we've received some public comment that has made a good case for increasing that period to 45 days. So we are recommending that change. One of the reasons that works is that officials under the definition of gift can avoid receiving a gift if they, within 30 days of receipt of the gift, return it to the donor. So this gives the agency sufficient time to wait for the 30 days to pass and see if the 802 needs to be filed or not. Secondly, this proposal would shift the primary posting responsibility from the commission to the agency which generates the reports. instead of sending them their forms to us, they would be posting the forms on their own website, which most of them already do. And all they would send to us would be the website link that would link to the agency webpage where that information appears. This change has been well received by those local agencies who've been in touch with our technical assistance division, and I'd like Trish to possibly give examples of that.
Hi, Trish Mayer, Technical Assistance Division. I'd like to read part of an email that we received earlier this year from a large city. It says in part that the department oversees lease contracts for some large stadiums in the city. And within these contracts, the city receives an allotted number of tickets per event at each venue. And during any given month, we can have up to 200 to 500 tickets, depending on the event. I would like to propose to have our link to our city's ticket disclosure webpage put on FPPC's site instead. This would, and then we would send your staff, instead of me sending and your staff uploading the hundreds of Form 802s, anyone could access the exact same information on our webpage. So that was a request we received earlier this year. And 2 weeks ago, I did a presentation before the city clerks at the new law seminar, and I mentioned this proposed regulation, and there was applause. Sure. So I think it was well received.
Thank you.
There is another change that we are proposing from the proposed amendment that's before you, and that would be on page 2 of the regulation, line 2. And the difference is that instead of saying a ticket or pass, we would change it into the plural tickets or passes. And this was also a request we received from interested persons. And that's just to clarify, if you're wondering why, it is made to clarify the fact that the agency head does not have to approve every single distribution of every ticket. So staff at this time requests adoption by the commission of amendment of 18944.2 as submitted with those changes.
44.1, I think.
Did I?
Yeah, that's okay.
18944.1.
Thank you. Okay, any questions or comments from the commissioners?
I have one.
Okay.
On the proposed change of page 1, line 18, just the syntax, the moving of the phrase for his or her personal use. What are your thoughts on that? It seems to make sense to me to what was proposed by the city of San Mateo.
To not move it?
Yeah, to leave it as it was on line 19 rather than move it to line 18.
I'll take the fall for this. Because when I was reviewing it, I kept stumbling on the way it is. I will argue that it is awkward either way. And
Fair enough. Fair enough.
And that for me, I could not understand the placement of for the official's personal use and what it was modifying. But maybe, and it just didn't seem right to have the comma, that phrase in a comma. So I talked with Val and Hyla, and we agreed that perhaps this would be better, but it seems to be debated. I think it is a better use, but again, it's still awkward. I think to make it perfect, perhaps we'd have to break down the subdivision more. But
Reasonable minds can differ. I'm fine either way. I just wanted to hear your thoughts on it.
or mine.
Your thoughts on it.
All right.
I don't think I should be adding anything once the chair has spoken.
All right. Any other questions or comments from the commissioners on this provision? Okay.
Yes.
Sorry. Go ahead, Commissioner Wasserman.
Hello, yes, this is Commissioner Wasserman. So this will presumably, hopefully, take a whole lot of burden off of a lot of different parties. Is there a process, or is it under contemplation, by which we do quality checks on the quality of these links and postings? As the websites for various agencies can get rather complicated and things can get stale very quickly. And hopefully there'll be less resources to do, but is there a thought on that, or is that still in process?
I think, Trish, do you want to address that?
Yes, as the reg mentions, we still are going to receive the ticket policy. So that number one, that's the first check to ensure that each agency has a ticket policy before we post the link to their webpage. And we definitely will continue to check the links to make sure that not only do they that statements are still posted, but that the links continues to go to that portion of the agency's website that contains the ticket policy, so that public doesn't have to search for them on the website, but instead the link goes directly to that page of the agency's website.
Thank you. Okay, any other comments from the commissioners, or we'll ask for public comment? Public comment?
Good morning, Chair Remke and commissioners. Just wanted to make a couple comments just to thank the staff for considering the comments.
I'm sorry, did you state your name?
I don't think I did. Sean Mason, City Attorney for the City of San Mateo, and representing the league's FPPC committee. Again, just want to thank Ms. Joyce. We had a couple phone conversations about the regulation. She was always accessible and helped me understand some of the language issues that we were discussing. So I really appreciate that. And again, thanks for the considering the 45-day period.
Yeah, that was a good suggestion. Thank you.
And have a happy holiday.
Thank you. Any other public comment? Okay, seeing none. Is there a motion?
I move approval of regulation 18944.1 as amended today.
Second.
Commissioner Darrow?
Yes.
Commissioner Kasher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Remke?
Yes.
This motion passes.
Thank you. Okay. The last thing are the executive staff reports. Do the commissioners have any questions or comments on the reports? Sure, which one?
Under legal, just on the very first page, the very first paragraph, we were continued until December 9th, and I wondered if you'd had a report on that.
Well, it's continued to a new date. What's the date on it, Heather? It's
Burgess?
Yeah, the Burgess. They're still setting the scheduling, the dates for
Heather Rowan?
briefing dates.
Heather Rowan with the Legal Division. We were continued again. The Burgess Council wants to amend his petition. We have another status conference on January 20th. He should be amending his petition by the end of December. So by December 31st, he's supposed to file. And I'm hopeful that on January 20th, we will actually have a briefing schedule and a hearing. Well, actually, the hearing date will be set later, but hopefully we'll have updates January or February for you. Okay.
Thank you. Any other questions regarding the reports? Okay, we'll go ahead and submit those then. Unless there are any other questions or comments from the commissioners, I move to adjourn the meeting.
Second.
Commissioner Darrow?
Yes.
Commissioner Kasher? Yes. Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes,
Chair Remke?
Yes. Thank you, everyone.
thanks.
Happy holidays.